Hi, my name is Jessica, and I'm a legal intern with the Avalon Center. The Avalon Center has a legal advocate who can give you more information and assistance with getting a protective order. The purpose of this video is to provide general information, not legal advice. And the options discussed are just possibilities and are not guaranteed in every situation. I'm going to explain what a preliminary protective order is and what the process of getting a preliminary protective order can look like. There is no guarantee that a victim will get a preliminary protective order. This is also not necessarily what the process will look like for everyone. It is just a possibility. Typically, a victim gets a preliminary protective order before getting a permanent protective order. So the steps for getting a permanent protective order usually build on the steps and information in this video. A preliminary protective order can prohibit acts of violence, force, or threat, and criminal offenses that result in injury to a person or property. They can prohibit the abuser from contacting and being in the physical presence of the victim's family, the victim's household members, and the victim's children. Can grant the victim possession of the home that the victim and the abuser share. Can order that the abuser not turn off any necessary utility services. Can require that the abuser provide acceptable alternative housing for the victim and the victim's family, household members, and children. Can grant the victim temporary possession of the car. Can grant the victim possession of a pet. Can grant the victim exclusive use and possession of a cell phone number. Can prohibit the abuser from using a cell phone or other electronic device to locate the victim. Can give the victim anything else that is necessary for the protection of the victim's family, the victim's household members, and the victim's children. These are just possibilities and are not guaranteed in every situation. Preliminary protective orders can also differ a lot. Some can be no contact, others can be contact but with certain restrictions, and some can be no violence, and everything in between. It is important for victims to talk to their lawyer about what will work best in their situation. Judges and magistrates issue preliminary protective orders in two situations. The first is when a victim has experienced an act of violence, force, or threat, and the second is when there is a warrant for the arrest of the abuser because of the abuse. A victim is not required to get an emergency protective order to get a preliminary protective order. Preliminary protective orders can be issued without the abuser being present or knowing that the preliminary protective order is being issued. However, the abuser will have to be given the order before it takes effect. Preliminary protective orders last 15 days or until a full hearing. The judge will say when the full hearing is, and it will be written on the preliminary protective order. The full hearing is when both the victim and the abuser get to present evidence at court to determine if a permanent protective order is necessary. Next, I will explain what the process of getting a preliminary protective order can look like. The first step to getting a preliminary protective order is going to court. The type of relationship the victim has or had with the abuser determines where the victim can request a protective order. To request a preliminary protective order, the victim will either go to the Juvenile and Domestic Relations District Court or to the General District Court. If the abuser is a family member, a household member, or child, or if the victim is a child, the victim will go to the Juvenile and Domestic Relations District Court. If not, then the victim will go to the General District Court. The legal advocate at the Avalon Center can provide victims with more information about where they should go to get a preliminary protective order. To court, the victim should bring the name, address, and information on how to identify the abuser. The address should be the place where the person can be found, for example, a home or work address. The victim should also bring the emergency protective order if there is one. If there was a warrant or petition alleging violence, force, or threat, the victim should bring that information. The victim should not bring a cell phone because they are usually not allowed in the courthouse. The second step is filling out court forms. To request the preliminary protective order, the victim must fill out court forms. If the victim is at the Juvenile and Domestic Relations District Court, the victim will file the forms with the Court Services Unit. If the victim is at the General District Court, the victim will file the forms in the General District Court Clerk's office. After the victim files the forms, The victim may then go into a courtroom where a judge may ask the victim questions to help the judge decide whether to give the victim a preliminary protective order. The victim does not need an attorney to file for a protective order, but getting an attorney can be helpful. It is frequently possible for low-income victims to get free legal services. The Avalon Center has a legal advocate who can be helpful in navigating the system. The victim should allow at least 2 hours to complete the paperwork and file it with the court. A protective order is different from pressing criminal charges. A victim can press criminal charges against the abuser and try to get a protective order, but pressing charges is not required to get a protective order. Also, there is no cost to filing for a protective order. There is no guarantee that a victim will get a preliminary protective order. It is just a possibility. If the victim gets a preliminary protective order, it will last 15 days or until there is a full hearing. Thank you so much for taking the time to listen to this information on preliminary protective orders.